The list, fresh admission, item 1.
May I please, your lordship? My limited grievance before your lordship. While a petition has been filed,
What is that? Yeah, an appeal is pending before collector
my lord,
or this
but
revision.
after 8 years, they have initiated the proceeding. That notice has been issued.
Right.
After that, we have-
all right. This is a writ application simply involving an allegation against the collector Nabrangpur in not undertaking the section 5 read with section 17 of Limitation Act exercise involving OSSA revision case number 355 of 2017. Considering innocuous prayer and after involving counsel for both sides, this court disposes the writ application observing in the event application by Danister 3 has not been taken up as of now. The collector Nabrangpur OP number so and so is directed to take up such application and give lawful disposal by completing such exercise at least within a period of 1.5 months from the date of communication of the order. This observation, the writ petition stand disposed.
oblige, your lordship.
Item not so.
May I please, my lord?
Where is certified copy of Annexure 1? You are challenging Annexure 1? There is no certified copy of Annexure 1.
But over here, my prayer is for
Pardon?
return of, over here, my prayer is for return of the service book, my lord. I'm not.
Pardon?
I'm there in WPC number 13688, my lord.
Item 2.
13688?
Yes, my lord.
Yes, I am holding that. Are you challenging
No,
Annexure?
no, my lord. Over here, my innocuous prayer is 2013. I faced a prosecution by CBI for commission of offences under the Prevention of Corruption Act.
Yes.
2018, it resulted in acquittal, my lord. But 2018 to
Oh, yes, you were
But
saying, you
my,
were
my
saying
service, my
once
service
the
book.
case is closed, they
Yes,
why
ma'am.
should they retain the service book? So CBI counsel can't they?
May I please, your lordships?
Mr. Satyajit Naik,
Yes, your lordships.
have you taken instruction if the case is already over?
Yes, your lordships. Your lordships, we have already applied for the certified copy of that. It was with learned trial court CBI judge, and it will be given to them, your lordships. I'm seriously pursuing it.
No, certified copy of what you are applying?
Your lordships, the instructions which I have received, your lordships, is that, your lordships, on 1/9/2016, it was in the CBI Malkhana record. After that, it was an exhibited document during the trial. So it is with the,
period over.
now it is with the learned trial court judge. It is in safe custody of the learned.
Directing to return in
Yes,
the,
your lordships.
there is no appeal and appeal admitted.
No, appeal,
Yes, your
appeal has been filed, my lord. Appeal has
Oh,
been.
he is
I'm sorry,
agreeing.
I'm sorry.
Agreeing, please follow.
Right.
He is saying if there is no appeal, there is no obstruction. Is it not? If
Your
there
lordship,
is no appeal, there should not be any obstruction and
Your
appeal.
lordships, appeal has been
Always-
filed, but still there is no obstructions, your
No,
lordships. We
no
can return it.
admission. Appeal has not been admitted.
Lordships, appeal CRL LLP 67 of 2019 is pending. Irrespective of lordship whether it is pending or not, also we can return it back.
You can return it back.
Yes, your lordship.
By retaining a copy, what is there? If
Yes, your
necessary, it will be called back again.
Yes, your lordships.
No, what is your instruction? If it's a CRLMC now. What is pending as against Annexure 1?
CRL LLP, my lord.
CRL
How
LLP
can there be
67.
how can there be a CRLMC?
That is
Or
the-
leave to appeal?
No. Appeal against the.
Or CRLMC টা appeal হবনি
সেটা leave to appeal.
সেটা leave to appeal হইতো
Yes, your
when it
lordships.
was filed.
CRLLIP.
Your lordships, it was filed in 2019.
Oh, so then it has not been moved as of now. Otherwise, it would have been converted to a appeal.
Yes, your lordships.
The submission of respective counsel ନାୟକର ନାଁ ଲେଖିବ ହେଲା ପ୍ରଭୁପ୍ରସନ୍ନ ବେହେରା ଆଗରୁ ଲେଖା ହଉଥିଲା ଏଇଟା ଇଏ ସାର୍ଥକ ନାୟକ counsel appealing for CBI. Read petition involves innocuous prayer in as much as the return of the original service book to the employer,
Employer.
to the
Yes,
employer,
my lord.
kept in custody of the CBI court for involvement of a case in TR 14 of 2013. There is no dispute in bar that this TR 13 of 2013 on the file of Special Judge CBI Court number 2 Bhubaneswar has come to an end by judgment of the court dated 24/12/2018 with an order of acquittal in favor of the accused. Undisputed, Sri Naik, however, submits, even though a leave to appeal has been brought to the High Court in 2019, there is no admission of the same as of now. For the settled position of law requiring retention of material object and the documents, if any, involving criminal matter possible till the expiry of the appeal period, and there is no appeal in the eye of law as of now.
Your Lordship, that should not be considered my submission because of the fact that the department may
No,
take it
no,
otherwise.
that is my observation.
Yes, yes.
That is my observation. I am not recalling, you said irrespective of appeal, the records can be also returned. I am not recording that. If I am giving my observation and allowing it. Okay. The appeal since has not been admitted. Further, even at appeal will be admitted later on, there is no difficulty in bringing back the service book of the petitioner herein on simply putting a notice against the employer in the further proceeding, if any. In the circumstance, this court finds there is no justification in holding over the service book of the petitioner, for which this court direct the
So
trial.
one line be added. Your Lordships, we have already filed for the certified copy of that service book before the
Okay.
lauded trial court.
Right. This court direct the trial court, Special Judge CBI Court number 2 Bhubaneswar, to return the service book involved herein to the employer involved. In the event by retaining a Xerox copy of the same. You have applied, you are given, not given, that's not the subject matter here.
Yes, Your Lordship.
Grateful, back.
Okay, Your Lordship.
Item number 3,
Item number 3,
Yes.
one a demarcation case, my lord, pending before the Tahsildar Satyavadi. So,
Okay.
direction only to
Okay, all right, the direction there. If such demarcation proceeding is pending, directed to be concluded, giving opportunity of hearing to party likely to be affected, at least within a period of 10 weeks
my lord.
from the
Okay.
date of communication of order. Yeah.
item 4,
Oh, I pray for a Passover here. Passover,
Passover,
yes.
Passover 89.
One
Item 4, my
Passover.
lords, that matter, my lords, the vigil crime branch is in possession of petitioner.
The time maguଛନ୍ତି ଆସୁ କାଲିକି ଆସୁ ଦେଖିବା tomorrow. Oh, you are also there, Sangram Daska na dekhibo. For vigilance na, oh,
Yes,
that
there-
case.
That case.
All right, let his counsel come thereafter tomorrow.
Oblate.
Mr. Das kona Delhi fees achi na consolidated? Delhi to? Right, all right. Yes, presence note kariwa na.
item 5,
Mr. Mahapatra ହସିଲେ ଯେ
ହସିଲି ଡେଲି ଫିସ୍ ମୋର ନାହିଁ ତ ହସିଲି
ଶୁଣନ୍ତୁ
ମୋର ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲେ 7,000
there the problem lies.
ଆଜ୍ଞା
ମୁଁ ଯୋଉ କେସ୍ କରୁଥିଲି corporate ର
ଆଜ୍ଞା
I never enter into a prayer court karo unless 8 since pending before OP number so eta commissioner from secretary panchayat raj OP number so who is directed to take a lawful decision on the same if necessary entering into inquiry in the involvement of the petitioner and also the parties likely to be affected by completing such exercise at least within a period of 2 months from the date of communication. Don't ask for interim order.
item 6,
Interim order.
My lord, item 6, Mutation appeal is pending before sub-collector
Just
Khordha.
1 minute. So any construction taken place shall be subject to outcome in the representation list. Yes, mutation case is pending.
My lord, mutation appeal
Appeal is pending.
for sub-collector.
What happened to notice? Notice has been served on the respondent there.
My lord, annexure 2, sub-collector call for the LCR from Tahsildar Bologada.
No, I am asking a question whether notice has been served on the respondent or not.
No, my lord, not.
No, then how can that be disposed? So direction they do a disposal is by way of dismissal without issuing notice. That's a possibility. They do a direction dismiss kar debe.
No.
How?
Sorry,
Please
sorry.
make genuine prayer to High Court. You come to High Court seeking disposal of an appeal where notice has been not been served.
Notice will be go.
No, please be reasonable. Withdraw. Come after the notice is served.
My lord, one thing, the Lawrence sub-collector.
I understand he has called for a report, but if notice is not served, what he will be doing with that report?
My lord, number has not been instituted. No number has been given in.
Undisputedly, there has been no service of notice on the respondent.
My lord, appeal number ही नहीं. No mutation appeal is there.
In the mutation,
Appeal number is
appeal
not there.
filed in 23, there is even allegation that the appeal is yet to be numbered even.
My lord.
Okay, considering submission, even though this court find no scope for targeting the appeal, but however, direct the appellate authority for at least registering the same and proceeding the matter in a way to give a lawful disposal, but in the involvement of the party
Fine.
likely to be affected. Second case, same.
My lord, second claim same. Through direction to Satyavadi Tahsil for lease case to dispose
No,
of.
second case ta kono?
My lord, this is
Second case is not in on appeal.
no, my lord, not in appeal.
Second case re kono ichi?
My lord, grievance petition Tahsildar को दिया है to disposal of my appeal lease case.
For disposal of
Lease case.
Lease case. My
lease
lord.
case.
Lease case.
Okay, all right. Considering
274 का ही उठा
it-
लेंगे.
considering it a puri ru କରୁଛନ୍ତି ଆପଣ?
My lord, my lord.
PVC ହେଲା. Considering there is already request involved in the giving a lawful disposal to lease case 234 of 1998. This court disposes the writ application directing competent authority to give a lawful disposal to the lease case 234 of 1998. However, in the involvement of party likely to be affected within a reasonable period of at least 4 months from the date of communication of order. Copy of order. These are data free copy there. Yes.
Item 7,
Lordship, may I please? Lordship, one report was leaked out in favor of the petitioner under Annexure 1, 28/2021. Thereafter, rent dispute under Annexure 2.
No, you want
My prayer is, my lord,
complying the direction in Annexure 5.
my lord. The fact is, my lord,
Okay, prayer kar de. Court kari lekha, considering the submission of respective counsel, this court observed. In the event there is no further challenge to the order dated 4/11/2020 involving revision petition 1387 of 20, the order involved by Annexure 5 is required to be worked out. In the disposal of writ application, this court direct the competent authority to find if the order involved is under challenge and stay operating by a higher forum, and in the event there is no such proceeding arising out of order at Annexure 5, the said order should be given workout. The work should be worked out at least within a period of 1.5 months from the date of communication.
Okay.
Free copy.
item 8,
I may please lordship. Here, the present petitioner challenging the action of the opposite party number 3 Tahsildar, demanding the conversion fees premium. Instead of 30,000, he is calculated rupees at the rate of 3 lakhs per acre, your lordship. My response submission, lordship.
Is it not applicable?
My responsibility similar matter lordship, this honorable court has directed here my
So
similar,
go to appeal and show that judgment to him.
what happened, my neighboring plot.
Appeal is there or not?
Yes, your lordship, under
So
58,
then
there
go
is,
and file
your
appeal.
lordship kindly glance for a moment. My neighboring plot, I have given the annexure 3 series. The same Tahsildar has converted the said land of
No,
her.
there is no
In by
possibility of disposal of repentation if a statutory appeal there.
My pray one thing, your
You
lordship.
may pursue with your repentation, but I will not give any direction there.
Only your lordship kindly write my by I am stating the
No, that's not possible.
with
That's not possible.
the clear case of discriminatory lordship.
Sorry, as you decide, you take a dismissal order or withdraw.
Lordship, my
Withdraw with a liberty to file appeal.
and that may be
If
kindly.
you have a judgment, then you show it to appellate authority. That neighboring plot is charging so and so. How can he charge this? High Court cannot at this stage interfere in these matters. It's a revenue matter, right? Should come through the revenue authorities first. Krishna wants to withdraw the writ application in order to avail the statutory
And-
remedy appeal.
And that may be by within a week I filed the appeal, that may be disposed of within a period of 4 weeks, your lordship, thereafter, let's say.
4 weeks, how it is possible? Notice given or nahi?
It clear case covered by
Sorry,
this judgment, your
sorry.
lordship.
If an appeal is brought within 7 days, there should be lawful disposal of the appeal within reasonable period of time. That's all. Yes.
Preferably, your lordship, 6 weeks.
No, ଆପଣ କରି ନ କରି କାହିଁକି ଆସିଲେ ଏଠିକି?
Lordship.
ଆଉ ଆସିବେ ସମସ୍ତେ ତ ତାହେଲେ ଆସିବେ ଆଜ୍ଞା ମୁଁ appeal ଟା କରିନି ମୁଁ 7 ଦିନରେ କରିବି ସେ 15 ଦିନରେ ସାରିଦେବେ।
ମୋର
ତାପରେ ବି ଆଉ ଅର୍ଡର ଦେଇଦେବା ଯଦି appeal dismiss ହେଲା ମୁଁ 3 ଦିନରେ ରିଟ୍ ଫାଇଲ କରିବି ରିଟ୍ ଟା ବି ସରିଯିବ 15 ଦିନରେ ଆଉ SLP ଫାଇଲ କରିବି।
Sri Jagannath Temple Act, my lord. Sri Jagannath Temple Act.
Jagannath Temple I am not hearing, okay. If it will go to, as this court is not hearing the Jagannath Temple matter, let the matter be placed before some other bench.
Item 10,
Item 10, my lord, counter copies of day before.
Pardon?
Counter copy ଟା सोमवार ପାଇଥିଲି only 1 day time to file the rejoinder reply ଦରକାର ପଡୁଛି ଏଥିରେ ଗୋଟେ ଦିନ ସମୟ ଦେଲେ ଫାଇଲ କରିଦେବା।
Counter file ହେଇସାରିଲାଣି?
ହଁ କାଉଣ୍ଟର ଫାଇଲ କରିଛନ୍ତି।
Just
My
now.
2 application have been rejected
Who
now.
is there for the central government or passport authority?
Monday ରଖନ୍ତୁ Monday ମୁଁ ଫାଇଲ କରିଦେବି।
ଆରେ ବାବୁ ଆମ ପାଖରେ କାଉଣ୍ଟର ଆସିଲାଣି କି?
ହଁ ମତେ ସର୍ଭ କରିଛନ୍ତି କପି ସେଦିନ।
ଆପଣଙ୍କୁ ସର୍ଭିସ କଲେ ଆମ ପାଖରେ ତ ନାହିଁ। It is stated, it is claimed by learned counsel for prisoner that there has been filing of counter by the passport authority. We service a copy on the counsel for prisoner even. Counsel for prisoner seeks time to file rejoinder. List this matter after the pleading completes.
Monday may prepare Monday.
After the pleading completed, file କରନ୍ତୁ rejoinder file ହେଲେ ତାପରେ ଆସିବ। Yes, next.
item 11,
Published.
Yes, Mr. Das.
Annexure 5 is pending, my lord. OP3, my lord.
What is annexure 4? It is already marked to competent authority.
Annexure 4 is
Your allegation has been already forwarded to some authority for their report.
OP7, my lord. Forwarded to OP7.
OP7, so
My
that has to be given a logical end.
My lord.
At the submission of Sri Das and Sri Ghosh, considering repentation of the petitioner while based on 6 herein is pending and already forwarded to OP number 7 for its opinion. This court finds the writ petition at this stage is not entertainable. However, in the disposal of the writ application, this court direct the ADM Kalinganagar Jaspur, OP number so and so to give a lawful outcome to the request of the petitioner by based on 6, at least within a period of 1.5 months from the date of communication of order. Yes.
May I
item
please?
12,
My lord, I will challenge the inaction of the opposite party for my lord Tahsildar, my lord. She is my lord to transfer the land, my lord, to the sport department.
Annexure 2 is pending.
Yes, my lord.
ଆରେ ଏଠି କଣ
Because-
ତାହେଲେ ଆଜିକାଲି ଶ୍ମଶାନ ଗୁଡାକ କଣ ଚନ୍ଦ୍ରକୁ ନେଇଯିବା?
The two
ଆପଣ କହିବେ ଏଠି ନ lawful disposal, but however, involving parties likely to be affected within 2 months. ଆସିଲାଣି ମୋ ପାଖକୁ 5ଟା ଖଣ୍ଡେ ଶ୍ମଶାନ କେସ୍ ଆସିଲାଣି।
ଗୋଟାଏ ଶ୍ମଶାନ 5 ଥର
ସେ ଆଉ ଗୋଟେ ଜାଗା କଲା ବେଳକୁ ସେ ଗାଁ ବାଲା ଆସୁଛନ୍ତି ଇଣ୍ଟରଭେନ୍ କରୁଛନ୍ତି ଆଜ୍ଞା ଆମ ଗାଁ ଦାଣ୍ଡରେ ହେଇପାରିବନି। କେତେ ଶୁଭ ଜାଣିଛନ୍ତି ଶ୍ମଶାନ ଟା ପାଖରେ ରହିଲେ ଲୋକ ଗଲାବେଳେ ମୁଣ୍ଡିଆ ମାରିକି ଯାଆନ୍ତି। ବହୁତ ପୁଣ୍ୟାତ୍ମା ଥାଆନ୍ତି ସେଠି। ତା କଡରେ ସେ ଦହିବରା ବାଲା ବିକୁଛନ୍ତି।
13,
May I please your lordship? And
ଶୁଭୁନି ଟିକେ ମାଇକ୍ ଆଗରେ କୁହନ୍ତୁ।
my lord, annexure 1, under annexure 1. the
You
input
challenge
order-
Annexure 1. It is
input order-
it is final outcome in election.
No, interim application on 6th February
କିଛି
2000.
ଶୁଭୁନି ଆପଣ କଣ କହୁଛନ୍ତି। ମାଇକ୍ ଆଗରେ ଟିକେ ରୁହନ୍ତୁ।
এটা রিকাউন্টিং ପାଇଁ ଗୋଟେ interim application ଦେଇଥିଲୁ।
What was that interim application?
My lord, annexure 3. Annexure 2. My lord, annexure 2.
It is in the refusal of recounting.
Yes, my lord.
Okay, তাহলে notice কর দিও। Then final order already passed or not?
No. For argument, posting for argument.
You have filed the application,
Yes.
but this is not the situation. No application is necessary. There is no application for interim application for recounting is necessary.
Inspection and recounting of.
କାଇଁ ଆପଣ election petition ଦେଖାନ୍ତୁ।
My lord,
You must have a prayer in the end. There must be recounting and
Annexure
then
3.
giving an outcome.
My lord, annexure 3.
Annexure
Annexure 3.
6.
Petition 3.
Page କୁହନ୍ତୁ।
Petition of
ଆଉ ଟିକେ
election.
ମାଇକ୍ ତଳୁ କରନ୍ତୁ ଆଜ୍ଞା କିଛି ଶୁଭୁନି।
ଆଜ୍ଞା।
ଆପଣ ତଳକୁ ଯାଆନ୍ତୁନି ମାଇକ୍ ତଳୁ କରନ୍ତୁ।
My lord, annexure 3, the election petition.
ହଁ ପେଜ କୁହନ୍ତୁ। ନା ଆପଣଙ୍କ ଫାଇଲରେ ପେଜ ପଡିଲାନି। Annexure 3 ତ?
Yes, my lord.
Annexure 3 page 25 ଆପଣ ବ୍ରିଫରେ ପେଜିଂ ହେଇନି? ଆଉ କହୁନାହାନ୍ତି ପଚାରିଲେଣି 3 ଥର। ହଁ come to your prayer.
ତାଙ୍କର main prayer C.
Prayer C is there.
Recounting ହଉଛି ତାଙ୍କର main prayer.
That's a situation in the course of
Final
judgment.
outcome.
Declare that the election.
Judgment draw କଲା ବେଳେ ଯଦି ସେ feel କରିବେ material ଅଛି then he will hold on there and he will give a direction for recounting dependent on the outcome. The final judgment will be passed. So there is no question of filing an interim application here, rightly rejected. But however, I will observe any observation there will not influence the authority in deciding on prayer number C. Add the submission of learned counsel for the petition of at the stage of admission. Well, at a small judgment of background involving the case. Petitioner and private opposite party herein were candidate to you are the election petitioner?
Yes, my lord.
He is candidate to election for the Gram Panchayat. Marsaghai Panchayat Samiti, sorry, Panchayat Samiti, Marsaghai. Pursuant to election notification dated 10/1/22. Election being over and petitioner being defeated, brought an election dispute on the file of civil judge Kendrapada by the election miss case 1/22. The proceeding under section 39 of the Aida Panchayat Samiti bra
Sarpanch for the post of Sarpanch of Botida.
Sarpanch tale Gram Panchayat.
Gram Panchayat.
Gram Panchayat. Petition under section 39 of the OGP Act. Evidence is over. Evidence is over.
Yes, from the side of the petitioner over.
Only
Yes.
opposite party has not laid evidence. So this is no stage even. Okay. There is no dispute at the instance of the petitioner that on the closure of the evidence from the petitioner side, the petitioner brought an application by annexure 3 with following prayer, page 28 prayer. Objection being filed by annexure 4, this petition was heard and disposed of with an order of dismissal, 4 and 5 for your objection. Resulting filing of the writ application. This court looking to the prayer in the election petition find the petitioner has the following prayers. Supported with allegations contained in the election petition. Coming to the stage of the filing of such application, this court finds once a election dispute involves an outcome dependent on also in the involvement of a request for recounting, the stage for direction for recounting, if any, arrives only after the conclusion of evidence of both the sides, and further in the course of judgment, such an occasion arises provided the tribunal concerned is satisfied in having such contingency. Looking to the timing of the petition by annexure 3, only after the conclusion of evidence of petitioner, this court find not only there is no necessity of filing such petition, as such a prayer is already contained in the main prayer of the election dispute, but there was also no time arrived in considering such aspects. Thus, this court, while while observing that there considered an untimely petition and undeserving petition, and declining to interfere in the impugned order, this court simply observed the prayer for recounting, since is a part in the election dispute, shall continue and to be considered, shall remain and to be considered at appropriate stage as indicated herein above, clearly indicated herein above. In the further consideration of the question of recounting in the process of judgment after conclusion of evidence from both sides, if arise, decision on such issues shall be taken without being independently and without being influenced by the observations already made in the impugned order. With this observation, the petition stand dropped. Dita evidence hele, dita pleading and evidence jodi support karibo to lead for a recounting, then a direction comes for recounting. And recounting is dependent on the result, the outcome will come. आपको कौन दरकार थला ये स्टेज रे जाई आपण एविडेंस दे देले ताले कोन स्ट्रेंथन नहीं गला तार भी एविडेंस आसीबो
OP have not returned to file evidence.
Huh?
OP have not returned to file evidence.
Pardon?
Opposite party ଆସିଲେନି evidence ଦବା ପାଇଁ।
ତାହେଲେ ସେ କ୍ଲୋଜ କରିକିରି କରିବ ହିୟରିଂ ଜଜମେଣ୍ଟ କୁ ଯିବ ଜଜମେଣ୍ଟ ନବ ଆପଣଙ୍କ ପିଟିସନ କାହିଁ ଫାଇଲ ହବ ଆପଣ ପୁରା ଅଲରେଡି ମେନ୍ ପ୍ରେୟାର କରିଛନ୍ତି with coupled with allegation ଯେ ଆଜ୍ଞା ଏଇ ଭୋଟ ଇଆଡେ ପଳେଇଛି ସେଇ ଭୋଟ ଇଆଡେ ପଳେଇଛି ତାହେଲେ only piece of evidence available which is on record ଆପଣ ଜାଣନ୍ତି ତାଙ୍କୁ କହିବେ ଆଜ୍ଞା ଏକ୍ସପେକ୍ଟ କରିଦିଅନ୍ତୁ କିନ୍ତୁ ତଥାପି ଆର୍ଗୁମେଣ୍ଟ କରିବେ ସେ ଏଭିଡେନ୍ସ ନ ଦେଇ ପାରନ୍ତି କିନ୍ତୁ ଆର୍ଗୁମେଣ୍ଟ କରିବେ
Yes, ma'am.
all right I have kept it open yes
Item 14.
dismiss kar do the application
मैं
dismiss
दिल
but however with the observations indicated
Monday to fresh admission. My lord, fresh admission.
There is
In B.
addition of SRP of 21
Aye. 15.
tinta ka matters yeah
Aye.
all
Aye.
the three matters
Aye.
yes
Item 15.
yes 15
Here, my lord, the petitioner before your lordship are belong to scheduled tribe community, my lord. Petitioner allegation is that in the year 1980, the opposite party number 4 managed to execute the sale deed in his favor by his sale deed was executed by the father of the petitioners. And allegation and also the my lord, the inquiry report. The inquiry was made
Mr.
for
Mahanti come straight you are challenging annexure 3
Annexure 3, my lord. Annexure 3 is very
come
clear.
to annexure 3 what is that
Annexure 3, your lordship may see, that is the inquiry made pursuant to the direction of the NHRC.
and you have been provided with opportunity
Opportunity was given both the parties.
no here it is only notice stage
Yes, ma'am.
annexure 3 is only a notice
Yes.
so you go and defend your case there why are you coming to High Court
My lord, NHRC case was filed at the instance of the opposite
should
party.
I consider that at this stage you place your case there you will
My
get
lord, that case is no more there because the inquiry report that went against him. The petitioner
that
was the
stand.
opposite party number 4.
take that stand Mr. Mahanti before the authority who has issued notice
My lord, the inquiry report is there, my lord. It shows.
no you ask me to consider at this stage
No, my lord. Our limited prayer that the finding in page 31 that no consideration money was paid, we are in possession, and the sale deed was obtained fraudulently. Subsequently, he offered 11 lakhs. This is all a finding of the inquiry officer.
right
Inquiry made by the sub-collector submitted to the collector
right
at page 31. So let them take action in person as provided under the.
so you don't challenge annexure 3
I don't challenge. Annexure 3 is in our favor, and Annexure 3 is pursuant to the.
so you want the
Action should be taken in pursuant to
operation of
annexure.
annexure 4
In pursuant to Annexure 3, action should be taken by the.
annexure 3 means page 31 onwards
Yes, madam.
so this so cause notice has been given an outcome
Yes, madam.
has
This is
been
the
given-
outcome, madam. This is the
given an
outcome.
outcome
Yes, madam.
page 31 to 33 is the outcome
Yes, madam.
that is no further challenge
No further challenge. And interesting part is that, my lord, it is this. This was at the behest of the OP number 4. He posed himself to be a poor farmer. Now it was seen that he was the retired CDMO, and we are in possession.
all right see this court had the submission of Sri Mahanti and Sri Sahu respective councils taking this court to the development through an outcome running page 31 to 33 in an inquiry proceeding, Sri Mahanti claims there should be action pursuant to such conclusion. Well, this court considers the request here to be innocuous request and simply disposes the writ application directing OP number
1 to 3.
1 to 3 to work out
Who is the collector?
directions and observations by the communication dated 9/6/22, running page 31 to 33. This order is to be worked out, however, There is no challenge to such development by any party aggrieved, and there is no operation of stay.
In self-same plot, second appeal is pending. There is a
So that's why I said if there is no other dispute and obstruction.
second appeal is different.
Yes.
Item 16.
This is the relating non-registration of a mutation case, my lord.
Pardon?
Non-registration of the mutation cases by the
Uh-huh.
Tahsildar Sundargarh, my lord. Non-registration of mutation cases by the Tahsildar Sundargarh, my lord. As because the
Any mutation case pending?
no. As
No?
because the
Non-registration.
non-registration, my lord.
Non-registration of mutation case.
Yes, my lord. As because
Okay,
the
then
land belongs.
what is your allegation? You
As
extended
because
such
the
a-
land, as because the land belongs to Sundargarh, no probate is necessary.
Pardon?
The land belongs to the district of Sundargarh.
Hmm.
No probate is required as because the will.
No, that's right.
Yes, ma'am.
There is no probate necessary. That is already settled law.
Yes, my lord.
There is no dispute in that.
Yes, ma'am.
But how do you say your application is not been accepted?
We have submitted application 27.
କାହିଁ ଆପଣ କାହିଁ ସେଠି ଯାଉଛନ୍ତି ତାଙ୍କ ଦୁଆରକୁ ଆଜିକାଲି ପୁରା ହେଇଗଲାଣି e-filing? Go file, have e-filing.
Yes, your lordship director.
Yes, petitioner wants to withdraw the writ application to avoid the e-filing of the mutation case involved herein. You make a e-filing so that you will take a decision. ଆପଣ କାହିଁ ତାଙ୍କ ଏଇଟା ତ ବନ୍ଦ କରାହେଲା, ବଟି ବନ୍ଦ ହବ। ଆପଣ ପୁଣି ତାଙ୍କ ଦୁଆରରେ ଯାଇ ବାଡେଇ ହଉଛନ୍ତି।
ମାନେ application be considered according to unnecessary.
ଆଗ ଆଣନ୍ତୁ ସେଇଠି ତାକୁ satisfy କରନ୍ତୁ, argue କରନ୍ତୁ. There is already judgment of my court.
Yes, answer 5 is also there.
Right. ଆପଣ ଆଗ ଆଣନ୍ତୁ appropriate application ତାପରେ. Yes. Permitted to withdrawn, but I have with liberty. Please.
Item 17.
May I please, your lordship, this is with regard to the completion of a demarcation. by the opposite
Demarcation
party
case
number
is
3.
pending since 21.
Your lordship, earlier your lordship passed an order.
In
If
this case,
Yes, lordship, still is,
thereafter what happened?
your lordship, they engaged Omina, but the Omina reported kindly say annexure 6, your lordship.
Page,
6, annexure 6,
page.
page number 19, the last page.
Yes. This is a report dated?
This is a report dated 14/2/2023.
ନାଇଁ 2823।
Your lordship, 28/6/2023.
ଆଉ ଏତେ ହେଇଛି ଜମା 8-10 ଦିନ କି 15 ଦିନ ହେଇଛି ପଳେଇ ଆସିଲା ହାଇକୋର୍ଟ ପାଇଁ।
ନା 8-10 ଦିନ ନୁହଁ, ଲିଡ୍ ଅର୍ଡରଟା ହେଇଥିଲା 2/1/2023 ରେ।
Right, ହେଲା, there is some constraint and report is already called for. So let
The
it
report
take a
ବିଶେଷ,
decision.
your lordship kindly the ବିଶେଷ ଦ୍ରଷ୍ଟବ୍ୟ ଦେଲା ଯେ ମାତ୍ର ଆରମ୍ଭ ସମୟରେ ପୋଲିସ ପ୍ରଶାସନ ନୋଟିସ ପାଇଥିବା ସତ୍ତ୍ୱେ ଅନୁପସ୍ଥିତ ଥିବାରୁ ମାପ କାର୍ଯ୍ୟ ଅସମ୍ପୂର୍ଣ୍ଣ ରହିଲା।
କୋଉ ପେଜ ରେ ପଢୁଛ?
ପେଜ ନମ୍ବରଟା 19 ର ଲାଷ୍ଟ ରେ ବିଶେଷ ଦ୍ରଷ୍ଟବ୍ୟ ଲେଖା ହେଇଛି।
କୋଉ ପେଜ ପଢୁଛନ୍ତି?
ପେଜ 19, your lordship।
19 ହଁ, ମାପ ଆରମ୍ଭ ସମୟ ପୋଲିସ ପ୍ରଶାସନ ନୋଟିସ ପାଇଥିଲେ ମଧ୍ୟ ଅନୁପସ୍ଥିତରୁ କାର୍ଯ୍ୟ ଅସମ୍ପୂର୍ଣ୍ଣ। So ପୋଲିସ କୁ ସେ ଲେଖିବେ,
Your lordship,
ଆଉ ଥରେ ଲେଖିବେ।
your lordship directed earlier, if necessary they may take the help of the police. Your lordship kindly this is
All
the
right, this court takes serious cognizance of non-compliance of order dated 2/1/23 passed in WPC 35744 of 22. Perusal of Annexure 3 discloses that even though there has been some progress to conclude the demarcation proceeding, but the demarcation proceeding could not be concluded for non-cooperation of the police. This court in disposal of writ application, looking to the development already taken place, this court in disposal of the writ petition observed as desired, the Tahsildar involved shall make a fresh requisition for availability of police, and on receipt of such requisition, the IIC concerned is directed to cooperate the Tahsildar by deputing police personnel for working out the demarcation exercise. The proceedings should be concluded at least within a period of 1 month hence.
obliged to courts.
Item 18.
May I please, Lordships? Impugned order is at Annex 6, page 39. And this is that matter.
Same
Again.
order. All right.
Oblations.
Item 19.
No, I please.
Yes.
Instrumental H4, annexure 2 relevant page 20. Last paragraph, my lord, the Child Welfare Commission, Baleshwar, directed OP number 4 to
You
rescue the child from.
challenge the CWC order.
Scheduled order passed on dated 15/4/2023. My
You
lord.
challenge that,
Not challenge, not implemented till date.
but it is not implemented.
No.
There is no further litigation.
Further litigation, not both sides are not only this petitioner approach personally for the OP number
No,
4.
there is no further
No,
litigation
no.
to block this. There is no further
No,
litigation.
my lord.
Okay, consider the submission of Learned Counsel on the read petition involving a request for working out the direction by the necessary to this court in disposal of writ application observed in the event. Order number 6 dated 15/4/23 passed by CWC Baleshwar, if not obstructed by any further proceeding through higher forum, should be worked out at least within a period of 2 months of the date of communication of order. Let the petitioner serve copy of order along with copy of petition on OP number so and so within 7 days. Free copy to State Council. जोड़ा का सब direction दिया होती सब free copy रहे. Yes.
Item 20.
Please, Lordship. My case is, Lordship,
Pardon?
but number 5 not receiving my application.
Mike रे कौन तू? Yes.
Opposite
Please.
part number 5,
Huh?
opposite part number 5, Lordship, not receiving my application,
Has dismissed your application,
not receiving, Lordship,
not receiving.
Lordship.
What is the nature of application? Oh, that ASO order. Can you copy
Yes.
दियंतु? ASO को direction दिया होनी on an application being served. Chief
order in
Justice
the
of
Annex of
Judgment
Progress.
and my
Annex 4, Lordship, similar order was passed.
Annex 4 रे अच्छी, मोरी order अच्छी.
Lordship,
Page Annex 4. Page 82. All right. ठीक है. All right. All these cases same.
discussion.
The division bench order challenge ही नहीं तो.
Hey,
So you have accepted that.
Item 21.
Lord, this the matter will connect, similar to the matter your Lordship has passed that order. Here in this case, I had got a lease from IDCO for construction of the township connected to the plant, my lord. My lord, the IDCO had written to the SP way back in around 2022. Your Lordship kindly see page 42. Page 42, your Lordship kindly. IDCO had written to the sub-collector, copy to the collector, that law and order situation is there, please help them for construction of the unit. Thereafter also, nothing happened.
So let us issue notice.
My lord, your Lordship,
In
this case only.
In the meantime, if you on your own, you can provide police protection.
there is a civil suit decree. Civil suit.
Yes.
Yes. Permanently listed to unknown persons.
No, blocking his right or creating a right in his favor.
There is a restraint order.
So, counter file करो.
Yes, sir.
Issue notice on the question of admission, है ना? Requisites accordingly कर दो. Place the matter. Three. IDCO is to be noticed.
My lord, IDCO not necessary. IDCO at least I mean rely IDCO is a formal party.
So only state authorities.
Only state authorities.
Okay. Place the matter 3 weeks up. Counter if any be brought in the meantime, well, extra copies they the state को. IA ऊपर करीब as an interim measure, this court direct, provided there is no lawful obstruction এটা construction matter টা।
No, construction matter hele batan we are now IDCO says that we will cancel the lease because we have not been able to do it. So Lordship direct for as usual thinking of Lordship police protection my lord that the other way my lord your Lordship the way Lordship directed that is a better order.
The
But
order you have provided there, the transportation was blocked.
no, not only transportation, Lordship also said about the
Provided
frame,
there is no lawful obstruction. It becomes the responsibility of the law and order authority
yes.
available locally to provide necessary protection to the petitioner. In work, in commencing his construction activity.
Para 14 of the writ, there is a representation pending before the sub-collector on 10th of July, 10th of July, this month.
So you ask him what is the action he has taken. Why people come to read court for this purpose?
Just in this month, 10th of July.
Only.
Yes.
No, IDCO मुझे देखिए IDCO लिखी थी सब कलेक्टर को 2 years back.
All right. 3 weeks of परे आसु देखो तो lawful obstruction किसी अच्छी की नहीं.
Hey, lawful
जति
obstruction
नहीं,
एटी किसी नहीं local
जति
गुंडागिरी
नहीं, तार client को advise करो तो कहना it's now a natural phenomenon. ये जो टी काम आरंभ कला तो कंडे जाई पहुंच जाऊ.
And the second read, 18th of July.
18th of July.
Yes.
So
नहीं
therefore
second
notice कर दवा same order करिबा आपण counter file करो.
Yes.
No, what he said this is a subsequent correspondence. There has been correspondences earlier also.
yes I have shown that.
Yes.
Because you are
So-
not working, he is compelled to issue another, maybe recent one.
And there
But
is,
काहीं जने 3टा 4टा representation दबो reminder काहीं करियो.
there is a civil court restraint order.
IDCO भी लिखी दोची किंतु
So find out civil court judgment is
no,
favorable.
civil court has nothing to do with this case.
And civil court
It
judgment.
is in our favor. It is in our favor. Instead of no known persons. It known person.
Civil court.
I have also
state is
filed a copy
party.
of the document.
Civil court state is a party. Civil court state is a party or IDCO is a party.
No.
So that has nothing to do with the state. It is a law and order issue.
Private parties.
It's a law and order issue.
Yes.
So therefore, if somebody is in property right, his right will be protected or not.
Yes.
Rest is left open to the parties to thrash out before appropriate court. ଏଠି କଣ ହୁଏ state ଯଦି slow ଯିବ ତାହେଲେ it is an advantage to the adversary to get into a court and get an order obstructing. It should not be
ସବୁ କିଛି local gunda with under the protection of the local politicians.
ଦିଟା ହେଲା next case.
The next item melody it is similar to the earlier matter.
Same order.
No, not same order. Melody also with this order.
That is transportation.
Yeah, transportation
That is
and as well as
transportation.
the blockage of gate.
Okay, transportation ହେଲେ ସେ first case ର
Blockage of gate also.
notice ଯିବ, counter be filed within 3 weeks. एटा स्वस्तिक इस्पात को ब्लॉकेज କରୁଛନ୍ତି.
Yes, my lord, blockage.
So miss case रे କରିବ ना.
Blockage transportation ସବୁ ତା ଭିତରେ ଆସୁଛି. ସବୁ ତା ଭିତରେ ଅଛି.
All right, miss case ଏଟା को SP
ଏଟା ହଉଛି ରାଉରକେଲା
ସୁନ୍ଦରଗଡ଼ ରାଉରକେଲା.
ରାଉରକେଲା
has a SP, right? এটা তো covered order আরেকটা ଦେଇଛନ୍ତି interim application টা সেই লাইন রে. Next. Senior
Item
counsel.
23.
Yes, 23. Is it fast contempt?
Fast contempt.
Fast contempt order.
Oblige your lordships.
Yes.
Item 24.
24, may I please your lordship? This is a fast
Fast contempt.
Fast contempt ସେଥିରେ ଗୋଟେ OEA case pending ଅଛି ଯାହା ଫଳରେ ଏଟା comply
Oh,
କରିବ.
why don't you intimate the observation? ଆପଣ ଯଦି obstruction କିଛି ଅଛି, read ର direction କଣ?
Let me issue direction, your lordship.
Disposal of mutation case. So you can put a halt to the mutation
Yes.
case, or suppose a right adjudication is pending somewhere, you can prepare, you can get into the mutation with the observation, it will be subject to outcome of so and so. But why you sit over? Fast contempt ରେ dispose କର.
ଦେଇଛି.
ହେଲା conditional କରିଦିଅନ୍ତୁ, ଆପଣ advise କରନ୍ତୁ client କୁ.
Item 25.
25 lordship is fast contempt. Fast contempt.
Fast contempt. यार किसी आउटकम आसछि कि नहीं तो फर्स्ट कंटेम्प्ट फर्स्ट कंटेम्प्ट दे दो डायरेक्शन राइट अच्छी अच्छी रखी था कहबे से He has come to orders.
For orders, item 26.
Mr. Mahanti, Mr. Bhagwan Mahanti, you have any objection to the intervention?
I am appearing for the
No, who appears for the petitioner?
I am for the petitioner.
So have you got any objection to the intervention?
I have filed intervention application.
How can petitioner file an intervention?
No, not impletion of party.
So therefore impletion of party you have filed.
Yes, I have filed.
What is the interest with these new parties?
My new party, just LIC Housing Finance Limited is a side effect of the LIC itself, according to me. He assured me to finance, and thereafter they did not.
No, then what is the direction? Is any direction against this party?
Yes, finance, not against the minus the LIC has cancelled my allotment, though I paid money. The problem is because of the assurance of the housing, LIC housing finance.
All right, we are allowing.
Yes.
You add them and then notice will go on such party.
Yes, but I'm if he's to
No,
appear.
you volunteered to appear for LIC.
Yes, madam. No, he is appearing for LIC. I am appearing for the LIC.
LIC party already existing.
Yes, madam.
Now the finance you are.
Notice is to go in this. Housing is.
Oh, I am passing that order both sides engaged.
Yes, yes.
I approve. ମୁଁ ଆପଣମାନଙ୍କୁ ଦେଖି ଦେଇକିରି ଜାଣି ଯାଉଛି ଯେ ସିଏ objection କରିବେ. That's why I say you on addition of a fresh party notice has to go.
Yes, fine.
That's the order I am dictating.
Yes, fine.
The new party will be added as OP number so and so. As the last OP. 4. For a fresh party added to the proceeding pending here.
4 and 5.
4 and 5, all right. Notice has to go. Okay. While directing the assisting counsel to bring a corrected cost title, bringing in the new parties to the fold of litigation, there should also be filing of requisites on the writ application to be for purpose of issuing notice against OP number 4 and 5 as undertaken by Monday. Notice be issued to OP number 4 and 5 newly added parties, fixing short returnable date. Counter if any by such party also be filed within 2 weeks of their appearance. Yes.
Item 27.
Any interim order continuing?
Yes, my lord.
Interim order is there to continue or it is for?
My lord, my past interim order to continue.
Interim order to continue.
Can my lord fix up a date for you because this is
Yes, got the
2030 matter.
February 2024, first working week, February 2024. Because notice will go, they will come, they may file affidavit or not, again some request. एकाधरे फेब्रुआरी रखिदवा
सर एते दिन काई रखिबे एटा तेर मैटरटा घरटा सर मु पाइबा
ताले टार्गेट करबानी कहिदवा जे मैटर बी लिस्टेड कंसीडरिंग मैटर इज पेंडिंग सिंस 2013 बी लिस्टेड आफ्टर द
notice
immediately after the pleadings complete
after the appear manner
no pleading complete है
sir pleading complete sir pleading करिबे लागे रहियो से
13 काई व्यस्त होचंदी 13 रो मैटर हमर तो चललाणी मैटर 11 रु 15 चललाणी केत दिन लागिवो मु फिक्स करवाटी किछि नहीं मु फिक्स कर देबी आई एम नॉट देयर टुमारो
I know
so other bench may not like fixing such date. Therefore a new wanted to learned counsel for the petitioner to renew their prayer for early hearing of the matter in the month of October.
क्या October करते
how open याडे माटा केस पुरई चंती जे वो माने मुंडो खराब ही जाउची पार्लर लोको बेल रे गलेनी काई ताको हैरान करछ
Lordship, only a few,
रहलानी केते दिन रहलानी
only Lordship, may I only point out one fact, that is the allegation, the prosecution case is that the group of people went and murdered the victim. The specific allegation against this present appellant, bail applicant, is that he had fired the gun. Rest of them are on bail. That I'm not disputing, your lordship.
No, he has fired the gun. Where do you find that? That's a finding.
That is there in the FIR, your lordship.
No, FIR.
Only in the FIR, your lordship. And
FIR. It is
My lord.
trial still pending.
the trial is still going on.
So can you scan through the evidence and say that yes, evidence has also supported such affair?
No, in fact, in the peculiar circumstances of this case,
You will normally find no witness will come to evidence.
yes, no, lordship,
Oh,
I'm just
because-
pointing out the informant, in fact, has turned hostile even.
Hmm?
The informant himself has turned
So
hostile.
then it has to be ended in.
Lordship.
favor. Let us not observe at this stage anything.
Lordship.
Except similarly standing persons without entering into whether
Right,
parties
not
stand
like
in
you to
similar
do-
footing or not.
Lordship.
Looking to the period already undergone, I release.
Lordship.
There is serious contest by the state council involving the bail application involved herein. On the footing that there is clear disclosure in the affair that the appellant herein involved in gunshot. Okay, there is also material disclosing the informant himself has already gone hostile. Looking to the stage of the matter, this court is not favoring to give any observation at this stage on the merit of the case at this stage of the matter. However, only however, from the point of view that there are large number of accused already released already on bail, and looking to the present appellant has already undergone
6 years in custody.
6 years,
In custody, man, 3/1/2017.
6 years plus.
Hmm.
This court feels it appropriate to release the appellant herein, subject to, however, following conditions. One, he shall not leave the locality without leave of the police, local police. He shall attend to the local police station at least once in a month. And for the purpose, this court fix the last Sunday of the month. Last Sunday of
ବର୍ତ୍ତମାନ ଆଉ ପୋଲିସ ଷ୍ଟେସନ ନ ଦେଇକି ଇଚ୍ ଡେ ଟ୍ରାଏଲ ରେ ସେ ପ୍ରେଜେଣ୍ଟ ରହିବ କୋର୍ଟରେ।
trial ଶୁଣ ଧରନ୍ତୁ 3 ମାସରେ ଆସିବ, ସେଟା ତ କରିବା। You will cooperate, you will not influence, ସେଗୁଡାକ ଆସିବା, but ତାକୁ ଆଗ ବାନ୍ଧିଦବା, ସେ ମାସରେ ଆସିବ, ବିନା ଇଏରେ ବାହାରକୁ ଯାଇପାରିବନି, ଆଗ ସେଇଗୁଡା ବନ୍ଧା ହେଇଯାଏ। ହେଲା, there should not be any attempt by the appellant to influence or threaten any of the witnesses involved. Further, there should not be, there should the appellant should file an undertaking before the trial court for attending on each date of posting at least within a period of 7 days. 7 दिन भीतर से file कर देवे, एगुड़ा नहीं कि देखे, subject to all these conditions, the petitioner herein may be released on bail. Also, furnishing security to the sum of rupees. कौन तारा status कौन?
Only 11 witnesses has been examined till date. Out of 34 witness,
नहीं ता status कौन? मो financial status कौन तारा?
financial status मतलब poor,
Poorer.
बापा को मूल्य कम कर देते।
No, from the counsel appearing, it obviously appears. Bail petition, criminal appeal 302, the counsel appearing. It is obvious. So it is poorer.
Poor.
Okay, subject to furnishing security to the tune of rupees 20,000.
Lordship.
With one security, one surety. To the like amount. Hala?
Oh, bless madam.
ତାକୁ ବେଲ ଦବା ବୋଲି ଏଠି ମୁଁ 3 ମାସ ଗଡେଇ ସାରିଲିଣି। ଏଇଟା ଫେଲ ପଳେଇଲା କି ସେମି ଫେଲଟା ପଳେଇଲା କି ଦିଅ ଏଇ ବିଏଲଏଫ ଟା
Item 28,
restoration matter ये अछंती 28 रे आपण ना
I was for the earlier I was for the interveners. On that day they didn't appear.
कहां दी वर्तमान कहां दी से दिन भी से आसी नथले
सेदिन आसिलेनी सेति पई
सब बदल छल गई तेल 500 गुड कर दे
500 गरे आसीबो मंडे आसीबो
मंडे गुड
I just wanted to apprise that if it is restored, it is okay. But the issue would be that if the interim order is revived, then that will be contrary to single bench order of this court, division bench, and which was approved in Supreme Court.
Then in that event, Mr. Mishra,
My lords.
that cannot be a subject in a CMAPL. You may file an application to recall the interim order.
Which we had filed.
Because normal course is,
My lord.
on restoration, it will be a full revivability.
My lords. So in this
If
background,
there is any hindrance or obstruction in the meantime, you may bring an application in the
my lord,
revision
that's
to
a
be considered.
my lord, that's a primary objection to the
That's right,
restoration.
but that cannot be objection in a CMAPL. Because that's never a subject in a CMAPL.
My lord,
CMAPL is only
normally-
whether it will be restored or not.
No, my,
And if restored, then to what extent? There I cannot involve these disputes.
my lord, normally when my lord hears the restoration, my lord also sees whether.
Absolutely, revive. It is automatic revival. Then question comes whether it should be allowed to continue. So where the decision will be taken in CMAPL or in the writ application. So
I just wanted to apprise that these are the developments.
bring. Hey, Bare, you may succeed ultimately in not allowing, or court may, if feels at appropriate, court may hear it finally.
My lord.
That at least that may bring to the finality of the proceeding.
My lord.
Right.
That will be on Monday.
Senior counsel appear the record kar there is request on behalf of petitioner for adjournment matter to come on Monday. Yes, next.
Beg unconditional apology for my lord,
item
my lord,
29,
my lord, dismissed for default on 4/5/2023.
29. You are there in
23 my lord. 4/5/2023.
Kota culture.
29.
29.
Because I beg unconditional apology because it's my fault, my lord, it has been dismissed for default.
That's right, but limitation of
Limitation, my lord, 30 days because the conducting it is not.
limitation notice.
My lord, state is the party, my lord.
State is the only party.
My lord.
No, there are private parties.
Private parties, they are not they are no longer necessary party because my lord, you let's remind there is one boundary proceeding case.
ଶୁଣନ୍ତୁ ଆପଣ एकदम casual ହେଇଯାଉଛନ୍ତି ସମସ୍ତେ ମୁଁ ଦେଖୁଛି. You must know the limitations in a CMAPL. Read ରେ ତାକୁ notice ଯାଇଛି ନା ନାହିଁ?
They have appeared, my lord.
They have appeared. Therefore, you can't say their party unnecessary.
The party.
Here you can't argue. First, get an order there that they are unnecessary parties. Then only. So once they are there, already appeared, noticed. So notice has to go.
My only my lord.
ଏଠି ସେମାନେ ପକ୍ଷ ହେଇଛନ୍ତି ନା ନାହିଁ?
Pardon, my lord.
ଏଠି ପକ୍ଷ ହେଇଛନ୍ତି ନା ନାହିଁ?
Well, they are made party.
Obviously, they are made party.
Because my lord.
So notice in limitation. Accordingly, କରିଦବ ହେଲା. Place the matter immediately. Notice in limitation along with copy of CMAPL. ହେଲା. ଆଉ ଇଏ କରିବ accordingly କରିବ requisites as undertaken by tomorrow.
By tomorrow.
Registry directed to issue notice on the private opposite parties fixing short returnable date. Matter will be listed immediately after or 7 days after expiry of the date fixed by registry.
Date may be fixed, my lord, because date may be fixed.
पहली जो डेट टा से फिक्स करिवे रजिस्ट्री तारा 7 दिन पर लिस्ट हबो कहली से कोन डेट फिक्स करे हम कोन जानि छी अभी नोटिस भी कहूची जे फिक्सिंग शॉर्ट रिटर्नेबल डेट yes.
item 30,
May please lordship, my lord.
आपण एबे कोथिरे इंडिया रे ना इंडिया
I am through to see my lord.
ना आपण नोंती मु आडे कहूची आपण बर्तमान इंडिया रे ना इंडिया रे
इंडिया
इंडिया रे अछंती ओ आ याडे हनुमान टोपा लगै जंती
Because my lord, formally there is no formal. Non-formal.
Yes, next case.
Item
Item
30.
30, my lord. My lord, I am applying for the modification of order, my lord.
What,
In the
what
appeal order,
modification?
in place of 634 demarcation, it is wrongly mentioned as 534, my lord. Demarcation number, my lord. In the annexure 1, my lord, wrongly it has been written as 635, my lord. 535, my lord, 4, my lord. It is
Couple
actually
my lord,
634.
only notice by speed
634.
post, my lord. Notice by speed post.
If a normal notice to speed post.
Okay.
Yes, annexure 1.
My lord, demarcation case number 634 is right. Wrongly it has been written as 634.
So what can be done?
It will be
That's
modified
no
as
mistake
634,
on
my
the
lord.
part of the court. Why are you not bringing another case?
No, it is question of order, my lord. Order, it is wrong. But my
Yeah, annexure 1 रे demarcation 634/22 लिखा हला.
order 534 ଅଛି.
हम order रे कौन है गला? अच्छा अच्छा.
534.
All right, application allowed.
Problem.
Application allowed.
Problem.
Item 31.
Mr. Sahu, कौन है जीत रे?
Here the notice was issued and the government has to take instruction only the limited grievance melody. Your lordship can see the annexure 4. Your lordship's order.
Order late.
Let the order dated. Let 14/10/2022 in earlier read petition.
Earlier read.
Earlier read petition.
No, in this read, what is the modification you want?
The modification that one dead person was made as
Issuing
party.
notice to OP 4 to 10 except 6, who is
Yes,
dead.
4 to 10 is
My lord,
appearing.
I am appearing.
So 6 is dead.
6 is dead from
Okay, for there is
the legal errors are already on record.
for there is already appearance on behalf of 4, 5, OP 4, 5, 7, 8, 7 to 10.
9 and 10.
10 lordship except 6. 4 to
Except
10 except
Oh,
6.
ମୁଁ ସେୟା ଡାକୁଛି ଆପଣ କାହିଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି? ଉପରେ ଡାକିଲି 4, 5, then 7 to 10 except 6 ହେଲାନି?
Lordship.
ହେଲା? The appearance memo filed on behalf of such parties be kept on record since OP number 6 is already dead. Substitution not
Not
necessary.
necessary, they are already on record.
Okay, this court record the submission of Sri Sahu that legal heirs of OP6 is already on record. There is no necessity of substitution in respect of OP number 6. For the above order, there may not be issuing of notice against all
Well,
such parties.
May I pray your lordship can take up only short issue in.
Sorry.
And your lordship's direction, he has complied one part and one part he has not. Only for acceptance of rent.
More Atuta judgment reserve, I am not entering into any final hearing.
And your lordship fix up a date.
Fix up after my retirement, if you desire. Yes, next.
Item 32.
ଆପଣଙ୍କର ଚାରିଟା sentence ରେ dispose of ହେଇଯିବ.
Sorry. Yes, next.
Item 32, 8th line order ରେ ସେଟା ବାସୁଆ ଖାଇ ଜାଗାରେ ଲକ୍ଷ୍ମୀ ସାଗର ହେଇଛି। Modification ପାଇଁ ଆସିଛି।
Modification
Again.
to what extent?
Well, 8th line of the order, para 2 of 8th line,
Para 2,
8th line.
yes.
I have mentioned it has been reflected as Lakshmi Sagar instead of Baswa Ghai.
Matta.
No, my lord, this is WBC.
Okay, kar diyo. All right.
I give the certificate copy. Certificate.
Certified copy surrendered for correction. may be returned after making necessary corrections. Yes.
Item 33.
To the council, ne? Yes, 33 modification.
My lord, lordship has been pleased to dispose of the writ application and with a direction to consider the application before the JMFC. And during submission, I have submitted, and also it is reflected in para 6 that 2 cases are pending. But inadvertently, my lord, 1 case has been reflected in the order.
What
It
is
may-
the other, what is the other case?
That is
Where do you find that?
that reflected is GR 2447.
Okay, this
Another
is-
is just
passport
below that.
Passport? case.
Again, just below that.
Okay, all right, give it in a slip, the
My
other
lord,
case.
that is in para 6 already in the writ petition.
Okay, na, para 6 रे दीटा केस अछि, हमें गोटे केस रेफरेंस कर दीचे. एटा हियरिंग अजित मिश्र और मैडम साहब को कथा देखिए.
Alright. And time period maybe
Time period consequent, as a consequence of modification of the order dated date, the time period is again extended till so and so. जेती
2 weeks.
किया इतना सेती period
2 weeks.
2 weeks कर दो. By further 2 weeks. Yes, 34.
34, may it please, your lordships, modification of order, my lords. In para 2, in place of section 20 subclause 2, it has been reflected as section 22. My lords, order dated 13/7.
Yes, all right.
And my lords, in para 3, section 20 subclause 2 and section 20 subclause 5. So that 25 है ये, 20 subclause 5 about 20 subclause 2.
All right.
Deeply obliged, my lords. Deep.
Yeah.
For admission, item 35.
Hearing किछि हेई परिबनी. No hearing possible now.
Only prayer, my lord, if your lordship will remand the matter, then.
Remand subject to consideration, subject to their acceptance, unless I am to give a judgment.
2016 ग्राम पंचायत फंक्शन करूची वर्तमान 2023 रे हमें कहूछु ग्राम पंचायत पड़ी.
Because she may get an outcome, but question is I am not in a mood to give any final outcome unless I clear my pending 8 cases.
Item 36. This is
Subuni.
item 36. There's a clear case of.
Withdraw karibe.
No, it should be remanded.
Huh?
Item 36. The matter should be remanded to the council.
Kaun pe, on what ground?
Because I was not heard. I was never heard. He
Okay,
said.
33 diyo.
36.
36.
36. 36.
I filed an application under.
मैडम आपन केस आसीबो आरो सप्ताह रे ये रोल करिवो लिस्ट रे किंतु हियरिंग हे
मोर भी आगे सही गोटे जिंस कहि कि
एठी कंसेंट आसी जाउची मु रेकॉर्ड करिविनी कंसेंट बट ऑब्जर्वेशन पाइबी जे हां इसे एक्सपर्टी ऑर्डर therefore there is a reason I can pass a short order. Once matters enter into contest, it is difficult on my part now.
This is an expert
So
order.
36, yes, please bring to that position that you are not heard.
I was not heard because at page 23.
Page.
Page 23.
23.
Before that, page 20, your lordship may kindly have a look.
20 helps him.
Yes, as it appears, my lord. Page 20.
Yes.
Hard ordering portion, hard learned counsel for the petitioner and opposite parties number 1 to 26 on merit of RC case number so and so filed under 37 of OCH PFL Act 1972, shortly called the Act.
But how he is writing this, then again writes opposite parties are
absent on call.
Had the submission of respective counsels involving an appears to be expertise order in revision case 35 of 16. There is serious allegation through the writ application that this order involving a 37(1) proceeding has been considered in the absence of the contesting opposite parties 1 to 6. Ki achandi other side
The other side-
ki achandi?
Appear korunahanti kehi to
He
notice
appeared for
sufficient.
separate notice.
Okay, all right.
That apart, he has dropped it on the ground.
Yes. Considering the rival contentions and after getting into the cost rate, the observation of the authority below in page 20, this court find there has been following recording. A to Porivo, returning 83. Page 20 ro pencil mark portion. Pencil mark portion. Okay, reading the above, this court find there is clear satisfaction on the allegation of the petitioners herein for their involvement of a ex parte order. Looking to the nature of proceeding, being a proceeding under section 37(1) of the OCH and PFL Act, such proceedings requires adjudication in the involvement of the parties. Such proceedings since involve deciding right title of parties ought to be disposed of in the involvement of parties to contest. For there is ex parte order involved, this court interferes in the impugned order annexed 2 and set aside the same. However, for there is fresh requirement of the hearing of the proceeding in the involvement of parties, this court, while remitting the matter back to the Commissioner Consultation Orissa Bhubaneswar, direct the parties herein to appear before the commissioner, at least appear before the commissioner by 1st of August, along with the copy of order of this court.
Item number 35 रे किसी judicial order pass होवन तो and that is an interim order.
ଆଉ ଆଜି ଟେକ ହୁଏ
No,
ପୁରା
item number 35 रे ସେଇଟାରେ କିଛି judicial order କିଛି ନା because that is an interim order till next date. Item number 35, which your lordship was not inclined to take out.
There is no interim order.
There is an interim order, my lord.
interim order to continue? Will continue. Whichever is adjourned, interim order will continue. Don't worry. Yes, contempt question.
Item 37.
କଣ ଦେଇଛନ୍ତି ଆପଣ ଏଠାରେ? The alleged deliberate violation of the direction of this court in WPC 2501 of 2022. Reading the order required to be complied, this court find the single bench had the following directions. Para 7 and 8 in the WPC 2501 of 22. While petitioner herein alleges, makes serious allegation of non-performance of the competent authority in the disposal of OLR case 2377 of 75. State Council brings to the notice, Sri Sonok Mr. appearing for the contemner, brings to the notice of the court as an instruction memo indicating there is obstruction in the finality of the proceeding OLR 2377 of 75 for reason of pendency of a mutation appeal on the self-said property. For the opinion of this court, proceeding under the OLR Act is of a serious nature, whereas the proceeding pending before the mutation authorities under mutation manual or even under the survey settlement provisions are innocuous matters only in the preparation of record of right. For there is a greater adjudication required in the OLR proceeding, there should not be feeling of a block by way of pendency of a mutation appeal. Law is also fairly well settled. Order, if any, in the mutation appeal shall ultimately abided by the proceedings under the OLR Act. It is in keeping this view, this court, while deprecating the unnecessary delay in pendency of the OLR through 2377 of 75, this court issues direction to the, as a matter of last opportunity, this court provide the contemner opportunity by providing him to give a lawful outcome to the OLR case 2377 of 75 at least within a period of 1 month. In the process, this court issues the following directions. Let the petitioner appear before the competent authority deciding OLR case number so and so on 24th. Sorry, kali ki taku order 25th kar diyo, 25th. Along with a free copy of order to be handed over to the petitioner tomorrow. Kali apna asibe itu order copy nei jibe.
Sir, aji certified copy pin dakhal kar debi aji.
हाँ?
Aji dakhal karbi sir certified copy pin.
नहीं नहीं
Eli sang sang debi.
काली आसिकिरी आपण इठू ऑर्डर आज जो ऑर्डर हैला से ऑर्डर टा नहीं जिवे कोर्ट मास्टर हैला on the petitioner appearing along with the copy of order. Free copy of order be also handed over. Aita free copy diya avani contempt se हैला on the copy of the order and appearance being made before the competent authority on 25th. The competent authority shall give a positive date of hearing to the petitioner then and there itself, at least giving a gap of 7 days.
Okay.
The matter shall be, apna samay nebeni.
Sir,
Hala.
samay nahi.
Matter shall not be ordinarily adjourned unless there is serious problem with the petitioner in attending the proceeding. And there should be a lawful outcome in the proceeding involved within 1 month hence. बुढ़ा लोग हारिबो जितिबो that's a different thing. Litigation habo. How बाकी जहाँ रहिला से सब आसीबो.
39 the entry mode to continue. Item 39 I have a small prayer.
Item 30.
39 I have a small prayer. In this case I am appearing for the opposite part number 6. I have not filed the counter. All I am praying before your lordship, since by virtue of an interim order is the construction of the building cannot be dispute relating to construction of Gram Panchayat building. The building construction of Hei Parune. All I propose before your lordship may protect them for another period of 8 weeks, but your lordship may dispose of the IA.
But mo pakhare asiparibo kya 8 weeks re I am not here.
Tapore कहले कि matter टा tapore if a date is not fixed and the IA is not disposed of, your lordship knows it will be difficult. All I am proposing, let him enjoy the stay. I am not on the merit. I am not on the merit. I am not. Again, was submission.
Place the matter.
Para 3 lords, we kindly
place the matter 8 weeks after.
Lords.
Date kar do, है ना? Interim order to continue till next date. Counter, if any, by private parties be brought in the meantime. Yeah.
Oh, blessed.
And there is a direction to collector to give some.
How kind lordy?
Item 38.
No.
38.
38 कौन हला?
सेटा ଗୋଟେ GA department ର counter necessary ଗୋଟେ time ଟା नोबो.
अच्छा 38 रे there is request by state council for 2 weeks time for filing counter. Interim order ଅଛି କି? ना नहीं interim order नहीं 38 रे देखि दो interim order से continue करिवो. Place the matter 3 weeks after. हला 4th week रे ଗୋଟେ date दो. कहने आने फ्राइडे करिवो हला से 5th week रो फ्राइडे को दे दो. हां ये सरला दैट
ये लॉर्डशिप आई बेग योर पार्डन मोर ओटे आइटम 28 थिला सेतिर आई कुड नॉट एबल टू कम बिकॉज़ ऑफ रेन मिल आसी पारि
रही छि पूरा मंडे को काई आपन पई के मागुथले से कहलेनी आपन को
ने ऑन लास्ट
पई के पास ओवर मागुथले मु कहली पास ओवर मु दिए नी थी जण मंडे आसीबो बोली ऑर्डर करछि
मु कहिथि
स्पेशल नोटिस दीटा कर
दीटा बेले गोटे मैटर फिक्स
हां ये से दीटा कहां दे वकील अछि
आइए हम तो फोन कली कहीं से धरना दे
ओके छाड़न देखियो आसी फाइल अछि दियो
से कोन आइए गोटे फाइल करछन से कॉपी टाइप देना
देखि दवा एते
से कोन डिस्पोजल कहउथले अनेक्स्टर 1 रिप्रेजेंटेशन
हां सेटा कहउथले आइए देखि दवा न नहीं तो जदी भूल थिबो कॉस्ट करी छाड़ दवा ये कहवा कथा जे रिप्रेजेंटेशन डिस्पोजल मैटर रे नोटिस इशू हे जे हां हैबा और देयर इज नो पर्पसफुल पेंडेंसी इटा हां पी आचार्य लेट अस सी दी आपण रीड रो प्रेयर ता देखंतु रिपीटिशन द प्रेयर ता देखिले मिस्टर
मतलब WPC 12301
हाँ 1 2 3
yes
Yes, directing opposite party to dispose of the application dated so and so.
Yes, yes. 6/10/2018.
ଏଥିରେ ନୋଟିସ ଇସ୍ୟୁ କରିଦେଲେ କଣ ହବ? ଆଚ୍ଛା ସିଏ ବସିଗଲା ହାଇକୋର୍ଟରେ ମ୍ୟାଟର ପେଣ୍ଡିଂ ଅଛି, ତେଣୁ ଆମେ ଆଉ ବଢିବୁନି। Okay, writ petition involve the following prayer. At the submission of Sri Acharya and Sri Ponda for the respective side, considering innocuous prayer involving and as there is no outcome on the application dated 6/10/18 stated by Danesh 1 stated to be pending, even in spite of 5 years passed in the meantime, this court in the disposal of the writ application direct opposite party, এটা sole opposite party ବୋଧେ
My lord.
କାହା ପାଖରେ pending ଅଛି Danesh 1 ଟା ଦେଖିବା ହେଲା, opposite party number so and so to undertake the disposal exercise of Danesh 1
ତହସିଲଦାର ପଟ୍ଟାମୁଣ୍ଡି।
OP ଦେଖିଦବା ହେଲା, ତହସିଲଦାର ପଟ୍ଟାମୁଣ୍ଡି OP କେତେ କହିଦିଅ?
OP1.
At least within a period of 6 weeks, but however involving parties likely to be affected. It is made clear this court has not expressed any opinion on either side. Our upper lekha, this matter was not in the list, but listed, brought to list by your special notice. Yes, next case. Next ଦେଖିଲ। ଏଇଟାରେ କଣ ମେନସନ କରୁଥିଲେ? ଏଟା ବି ଗୋଟେ କଣ ଇନୋକୋସ୍ ପ୍ରେୟାର ମେନସନ କରୁଥିଲେ।
ଆମକୁ କିଛି କପି ଦେଇନାହାନ୍ତି।
ଆଏଟା ପହଲେ କି କଣ?
ଆଇଏ ଫାଇଲ ହେଇଛି।
ସଂଗ୍ରାମ ସେନାପତି। ସେନାପତି
245/23 ମାଇନର 8
ଦେଖିଲେ ସେନାପତି ଅଛନ୍ତି କି ବାହାରେ?
245/23।
ଆଜ୍ଞା 8ଟା ପି।
ଟିକେ ଦେଖିଦବା ଖାଲି ହେଇପାରିବ କି ନାହିଁ, ନହେଲେ କାଲିକି ଆଣିବା ଆଉ। settling the tenement ଆମେ ସିଏ କହୁଥିଲେ ମିଷ୍ଟର ସେନାପତି was arguing, ସିଏ କହୁଥିଲେ ଯେ ଏଇଟା ଯେହେତୁ ମେନ୍ ଅର୍ଡରରେ ଟାଇମ ଷ୍ଟିପୁଲେସନ ନାହିଁ, ତେଣୁ ଖାଲି ଟିକେ ଆଉ ତାକୁ ସମୟ ବାଇଣ୍ଡ କରିଦିଅନ୍ତୁ। ଦେଖିଦବା ଆମ ଇଏରେ ଜଜମେଣ୍ଟରେ, ଜଜମେଣ୍ଟ 18168 ତାର ଗୋଟେ ରିଭ୍ୟୁ ହେଲା ପରା। ରିଭ୍ୟୁରେ ଅର୍ଡର କଣ ହେଇଛି? Okay, by bringing this application, the Senapati learned counsel appearing for the petitioner alleges for the review petition disposed of without any time frame to work out the direction therein. The opposite party number 5, 1 and 5 are simply sitting over the matter and not giving a lawful disposal. Considering innocuous prayer, and as this court find, in fact, there is no time target in the disposal of the review petition. This court gives 3 months time as a matter of last chance for working out the direction by it. ଆପଣ ଅଛନ୍ତି ପରା ମିଷ୍ଟର ସେନାପତିଙ୍କ ସାଙ୍ଗରେ?
ଆଜ୍ଞା ଆଜ୍ଞା।
ହଁ, ଏହା ତ ରିଭ୍ୟୁରେ ଟାଇମ ଟାର୍ଗେଟ ନାହିଁ ବୋଲି ସେ ବସି ଯାଇଛନ୍ତି ମ୍ୟାଟର ଉପରେ।
ଆଜ୍ଞା।
ସୋ ମୁଁ ତାଙ୍କୁ 3 months as a matter of last chance ଦଉଛି ଟାଇମ ହେଲା।
My lord.
The opposite parties required to work out the direction in the review disposal are permitted as a matter of last chance, 3 months as a matter of last chance from the date of order. Let a copy of the order be served by petitioner on the authorities required to take a call on the review direction.
Grateful man.
Hello, close to. Thank you. କାଳ ବେଳାଟା ଟିକେ ଅଧିକା ସମୟ ହଉଛି ନାଇଁ କି, ସେଥିପାଇଁ ହେଇଯାଉଛି।